Thank you, Star TV. Let me first of all express thanks and appreciation to God for making this program come to a reality. And also let me extend thanks to the director of Star TV, Mr. Philip Neville, for giving us this platform to promote e-learning in a COVID-19 environment. Let me also thank the manager, Mr. Abdulrahman, and of course his team, Ezekiel and others, Sienna, a lot of them, Leonora, they've all been so instrumental to making this program a reality. And clearly it fits into the agenda of His Excellency, our President, retired Brigadier Julius Madabio, which prioritizes education. And of course, in a COVID environment, the university has also authorized us to devise ways and means how we could reach students and ensure that learning still continues in the midst of the COVID environment. So this is one way the media are helping the nation in terms of providing the platform for some of us lecturers to still reach our students. So all my students, I'm sure you are tuning to Star TV and you are also with us online. Our lectures continue. We are now in the second semester, and so I'll be using this platform on Tuesdays and Thursdays to push the course outline in only two ways, so that when normalcy gets back to campus, we'll be far ahead of many other institutions. So, but again, even though this program primarily fitting to the law students, of course, if you are not a law student, you're also welcome. It's always good to have an understanding of the law, because at any time in life you might be in conflict with the law. And when you understand the law, you are at a vantage position to know your rights and be able to defend them when they are threatened, when they are violated, or when they are abused. So I am Rashid Umbuya, and today's topic will be premised on prerogative, remedies, and orders. So talking to my LLB 1 students, I've given you your outline for second semester, and primarily you will note in your outline that the first topic has to do with prerogative, remedies, and orders. So we are starting the lectures proper. So I will try to explain in brief some of the concepts, and then maybe in 40 minutes, and then we'll have a break where you guys will ask questions via the telephone line, and of course the text message line, and then on the WhatsApp and Facebook social media platforms. And then I will answer those questions accordingly, and then we round up. So let's save time and start proper. So when we talk about prerogative, remedies, and orders, so we have also a few students with us here, the class rep, and of course one of the assistants. They are also here. So they are witnessing it live in the studios, acting on behalf of you guys out there. So when we start, when we talk about prerogative, remedies, and orders, what do we mean? So basically, they are remedies which are usually applied by the High Court or Supreme Court of Sierra Leone in the exercise of their supervisory jurisdictions. Remember, I told you in your first semester about the jurisdictions of the various courts in Sierra Leone. And the High Court, we agreed, has supervisory jurisdiction over inferior courts below it. And also we agreed also that the Supreme Court has supervisory jurisdictions over all other courts. And so today what we are looking at is how the Constitution has empowered the High Court and the Supreme Court with supervisory powers. Because if you have a jurisdiction to supervise and you don't have powers to push lower courts when you are supervising them, to require of them certain things to do or not to do, then your supervisory jurisdiction on powers may be questioned. So what the Constitution did, the drafters, they were so intelligent, was to put certain powers in the hands of these two courts, such that when they now supervise lower courts and they want to disobey their instructions, they will just invoke those powers and ensure compliance. So that's all we are talking about today. Supervisory powers, prerogative remedies, talk about the and others, talk about the powers that have been given to the High Court and the Supreme Court to enforce compliance over inferior court. So basically, again, for definition purposes, there are remedies which are usually applied by the High Court or Supreme Court of Sierra Leone in exercise of the supervisory jurisdiction over inferior court tribunals or adjudicating bodies. And of course, they include writ of habeas corpus, orders of certiorari, mandamus, and prohibition. So we talk about mandamus, we talk about prohibition, we talk about certiorari, we talk about writ of habeas corpus. So I'll be going gradually, one by one, to explaining all of these orders and remedies such that you now understand them and know their relevance vis-a-vis the High Court and the Supreme Court. So let's start with the frameworks, the legal frameworks that provide the powers and the section therein. So we look at the Constitution, we note that Section 134 of the 19th Constitution of Sierra Leone confers on the High Court prerogative remedies and orders in the exercise of its supervisory jurisdiction over inferior court and adjudicating authorities in Sierra Leone. So it's clear that when you turn to Section 134 of the Constitution, you will note that the Constitution provided certain powers to the High Court, all right, in exercising its supervisory jurisdiction over lower courts, and these powers include certiorari, mandamus, prohibition, writ of habeas corpus, and so forth and so on. So all the Constitution has done is to give this court teaching powers. So when it supervises courts below it, it will always invoke these powers and ensure that they comply to its supervisory jurisdiction. So when it comes to the Supreme Court, we will find out that in Section 125 of our Constitution, it is clearly stated that the Supreme Court shall have supervisory jurisdiction over all other courts in Sierra Leone and any other adjudicating authority in the country. And in exercising that supervisory jurisdiction, it will have powers to issue directions and orders of certiorari, mandamus, or prohibition. So it's the same thing like the High Courts. The difference, however, which we should note here, is that when it comes to the High Court, these powers are enjoyed over courts below it. So, for example, the magistrate courts and other adjudicating authorities, local courts and the like. So it's about courts below it. So it will not enforce these powers on courts above it. So that's the difference I want you to know. When it comes to the Supreme Court, it has powers to enforce it over all other courts, so including even the High Court. Alright, so that is very important for you to note. So when we talk about supervisory jurisdiction, we are referring to basically the court having powers to enforce compliance over what it wants to happen or see happen over inferior courts. So there are times when you will see the lower court want to do something, certain things that may not necessarily fit into what perhaps the higher court is saying. So it must be given some powers to enforce compliance so that its decisions will be honored and respected. Let's start with habeas corpus, the writ of habeas corpus, quickly, so that we can finish this topic today. We hope to be finishing at least a topic every time we meet. So habeas corpus, what it means simply. A writ of habeas corpus literally means produce the body. It means produce the body, in quote, produce the body. Alright, it's a court order to a person or an institution holding someone in custody to deliver the imprisoned individual to the court that is issuing the order. It is designed primarily to protect the fundamental human rights of persons that have been illegally detained either in prison, hospital, or in private custody. So a writ of habeas corpus, in short, is an order. It's a court order, alright, directed to a person or an institution that is holding somebody in custody, alright, or imprison somebody, could be illegally, and it is basically requesting that person or institution to produce the body, to bring the person before it. That's basically what the order means. So when the High Court issues a writ of habeas corpus, it is basically asking for the person to be produced, all right, before it. So you don't have rights to defy that order, otherwise it will be contempt of the court. So unlike other periodic remedies, a writ of habeas corpus is not discretionary, all right. It is available as of right. So it means where there is evidence that before the court that proves that someone has been illegally detained, the court is under a duty to issue the writ. So as long as there is evidence before the court that somebody is being illegally detained, then the court is bound to issue the writ and ensure that the person is brought before it. So the court will usually address the writ to the detainer, commanding him to produce the body, the person who of course is detaining the person. So that is the person that the writ will be addressed to, and it will require him to bring the person to the court at a specific period or time. Alright, so it is the detainer's responsibility to convince the court that the detention is not unlawful. So if the writ has been issued to the detainer, it is now the detainer's responsibility to ensure that the court understands that he is not illegally detaining the person. So the responsibility or the burden shifts to the person who is detaining the order. All right, so the burden of proof will rest on him to show that he's not detaining the person illegally. All right. Now, it is also important to emphasize that the writ of habeas corpus does not impose punishment on the detainer over the legal detention. So basically, what it does is to set free the detainee, the person who is illegally detained, who has been under illegal detention. Now, it is up to the detainee to now pursue a separate course of action against the detainer, either for assault, battery, false imprisonment, or illegal detention. So the order will just basically set the person free, and it's up to the person now to pursue other course of action against the person who has illegally detained him, okay, for battery, assault, false imprisonment, or illegal detention. So this writ of habeas corpus application is usually made, of course, to a judge of the High Court by any person. So anybody can come before the court and make that application, or somebody acting on behalf of the detainees. It could be really a lawyer, but it could also be any person. The application must, however, be supported by affidavit. So you must have, as a process, you support the application with an affidavit. As you're making an oath that indeed you would know the situation that indeed this person is illegally detained. So you're swearing on an affidavit that the facts are true and this person has been illegally detained. All right. And something also important to emphasize is that the writ of habeas corpus can be issued on private persons as well as in criminal or civil proceedings. All right. So it's not just limited to a criminal proceeding. For example, if the police is keeping someone in detention, beyond the constitutional husband to allow his wife out of the house. All right. So somebody came and asked, the court for a writ because the husband was keeping the wife in the house beyond her wish. So that's a pure civil matter. So and that was also enforced. So in a private situation, so it's not necessarily between the police and somebody else all the time. So you can even come for a writ in a private situation. Also in Bernardo versus Ford, another case authority, in Bernardo versus Ford, 1892, a writ of habeas corpus was issued to secure the release of children that had been unlawfully detained. All right, here it was a criminal situation. The children were unlawfully detained, so a writ of habeas corpus was issued to secure the release of those children. So you see, it can apply both in private situations and also in criminal situations. All right. So note clearly that when it comes to the writ of habeas corpus, it's not a discretionary remedy. So the court is under a duty, so long as the facts have been made available before it, and somebody is holding someone illegally, the court is under a duty to ensure that it issued out the writ to require the detainer to produce the detainee. All right. So that's one powerful weapon that is in the hands of the High Court, for example, in ensuring that its supervisory jurisdiction is adhered to by lower courts, courts lower below it, and also, of course, other adjudicating authorities and bodies. All right. I hope that is clear. So let's move fast to the next, power or order. Certiorari. Certiorari basically is the shortened name for the Latin word called certiorari voluminus. Certiorari voluminus, spelled CERTIORARI VOLUMUS. Which simply means we wish to be informed. We wish to be informed. Certiorari means we wish to be informed. It is a remedy that orders a lower court, tribunal, or adjudicating authority to deliver its record in a case so that the High Court may review it. So where the decisions are found to be invalid, the High Court will quash them. Alright, so basically it's an order of the High Court requiring, or Supreme Court requiring, a court below it to bring to its attention, alright, the matter, it could be records, for a review. Alright, for a review. And that is so important. Perhaps something will have gone wrong, in the court below. And so the High Court is now requiring that court below it to bring the records before it. So it's saying basically, when the court orders or issues a certiorari order, it's basically saying that I wish to be informed. Please bring all the records before me so that I know exactly what has happened down there. And of course, where the decisions are found to be invalid, the High Court or Supreme Court will quash them. In other words, will overturn them or set them aside. Alright, so it's a very powerful weapon in the hands of the High Court and Supreme Court. Imagine you are a court and you have powers to ask another court below to come with records before you so that you can review them. That's a very strong power, and that's what is being enjoyed by the High Court and Supreme Court. Alright, but for an action for the remedy of certiorari to succeed, a person must have first the local standard. So if you want to bring an action to get the order for certiorari in either the High Court or Supreme Court, there are things that you must satisfy, and one of them is you must have the local standard. So in other words, you must have sufficient interest in the matter. Remember, it's a very strong and powerful remedy. So the court does not just give it as you may want it. There are certain things that you must meet, thresholds that you must meet, and where you fail to meet them, of course, you may not succeed in having that order granted. Alright, so there are about 3 grounds that also you must satisfy. Aside the one of the local standard, there's also other 3 things you must note, or grounds for an order of certiorari to be granted by the High Court or Supreme Court. 1. So where there's a lack of jurisdiction or excess jurisdiction. Where there is lack of jurisdiction or excess jurisdiction. So it means where the inferior court or adjudicating authority that are adjudicated on the matter, had no authority to have decided, or where it has acted beyond its powers. So for example, if a matter was brought to a lower court and that matter was never to have been decided by that court, that means that court, all what it did was out of its jurisdiction. So it has acted, or it lacked the jurisdiction. So that could be a ground for you to now come to the High Court and require it to issue to you or to the court below an order of certiorari. Alright, require it to bring the court before it and then reviewing it, and where it found that indeed there was a lack of jurisdiction, then it will quash the entire decision by the lower court. So it's a very strong remedy, but then you must find the grounds for you to bring that to the attention of the High Court or Supreme Court for that court's decision to be quashed. So one is lack of jurisdiction, another is excess of jurisdiction. In other words, where perhaps it's hard initially, but then as the matter progressed, it acted beyond its powers, or it varies. You can also come to the court for that order to be granted. Let me give you a case authority where this order was sought and successfully implemented. In Attorney General Fulham Corporation 921, the court decided against the corporation for acting ultra vires when it operated a commercial laundry instead of a cost recovery wash house for people's clothing. So the company basically registered for a particular object, for a particular purpose, okay, and that was for commercial laundering. Alright? And then on a cost recovery basis. And then it started doing something, out of its scope. And immediately that supposes that it has acted ultra vires, alright, out of its scope. So then an action was brought, and then of course the court had to issue the order. Two, another grounds where you can bring an action for this remedy to be sought is where there is a denial or violation of the principles of natural justice. Alright, so it simply means where an inferior court or authority had made a biased decision or refused to allow one of the parties to be heard or prevent a party from legal representation during the proceedings. An order of certiorari may be granted by the High Court to quash the decision of such inferior court or body. So no sooner you notice that a lower court has perhaps denied one party the right to representation in court, or perhaps the other party was not even heard throughout the proceedings, that's a fundamental breach of the principle of natural justice. So it's a sufficient ground for you to come to the High Court and try to overturn that whatever decision that magistrate or court below will have made. So it's a very nice thing to do, but you have to make sure you satisfy the grounds. So another ground is where there is a denial or violation of the principle of natural justice. A case in authority is Ridge and Baldwin, 1963. It was held that the dismissal of a chief constable by a committee without giving him the opportunity to answer the charges or make an appearance was invalid. So there was an allegation, but one party was not heard. So a decision was made. And of course, the lawyer had to challenge it to the High Court and sought an order of certiorari to quash that lower court's decision because one party was never heard. That was a fundamental breach of the principle of natural justice. The third grounds which you have to also bring before the court for you to succeed in this order is where there is an error of law on the face of the record. Where there is an error of law on the face of the record. So whether either the documents which is used to initiate the proceedings before the inferior court, or the proceedings itself, or the pleadings or decisions reached is based on an error of law, the decision may be quashed by the High Court. So just watch for those things. If even the pleadings, the documents that were served, there were errors, the judgments reached that were also based on error of law, even the pleadings, everything there was procedural error. So you can use those and then ask the High Court to now, make an order of certiorari to the lower court and then require all those records, and then you make a case, and then of course you have the entire decision overturned or quashed. Alright, so it's a good lawyer. Of course, the law students, you are a lawyer in the making, you must be sensitive to watch for these things and bring it to the attention of the High Court or the Supreme Court, and then get an order of certiorari to quash the decision of the lower court. Alright. A case in authority, again, remember we are dealing with law, so I'll be giving you a lot of cases, okay, so that at least you can understand that it is not the first time it's happening. Other countries like the UK, of course, we rely heavily on UK cases. They have been before us and they are looking at these things, and we have decisions that we can rely on. Alright. So RV Liverpool City Justice Ex parte Topping, 1983, a conviction by a magistrate was quashed on the basis of undue process. So the magistrate never followed due process, and so an order of certiorari was sought, and then the decision was quashed. So where the record, on the face of it, there was no process that was followed, there was procedural error, an error on the face of the record, you can use that as a ground to come to the High Court and Supreme Court and then get an order to quash everything. Now, what are the penalties if a court disobeys the order of certiorari? Yeah, because there is tendency for lower courts to sometimes act in contempt, to just dismiss. Okay, what is this? I'm not even listening to what is that. What is that? What High Court is this? What is he saying? So sometimes there is that tendency. So what is the effect of a lower court not obeying an order of certiorari? What will happen? Disobedience to the order of certiorari is, that is, if you submit a cause of a case that was decided in an inferior court to the High Court for a review, can be held as contempt of court. So when the lower court refuses to submit its records by virtue of an order of certiorari or quash its decision, then of course it's contemptuous. All right, and that, of course, we know the consequences when you act in contempt of a superior court. All right. The third one, so we're moving fast so that we can have more time to do some interaction. The third order is prohibition. An order of prohibition. So we're talking about the writ of habeas corpus. All right, produce the body. We have just finished the order of certiorari, which means we wish to be informed. The court is asking, we wish to be informed, bring the records, and now we are at the order of prohibition. So what it means? Yes.
A quick on before proceeding to the third element.
Yes.
Could this be a situation where perhaps even after a judgment or during lower court proceedings?
Yes. So it's a very good question, because sometimes people may want to wait till the decision is handed down by the lower court before we can now seek to the higher court to get the various orders, that we are learning today. So it's best practice. Sometimes people can do so, they call it interlocutory applications. But then again, in my practical experience, I do wait sometimes so that at least it's tough really, but I wait so that I can get the entire records, and then we can now file and then have it overturned.
So those aspects of interlocutory or interim injunction, prohibitory and mandatory, falls within the circumstance?
Yes, well, when you talk about injunctions, they are called interlocutory applications. So you're coming to ask the court to perhaps stop somebody from continuing or continue to do something that perhaps is unlawful. So it doesn't necessarily mean all the time a final. Okay, perhaps you can ask the court for an interim injunction at the moment so that it stops every party from continuing to do an act, and then later on until the matter is finally determined. So the matter can be determined by the judge, and then of course ultimately give a very strong remedy, which could include also an injunction, or a perpetual injunction, so that nobody or the person doesn't ever enter the property. But then this orders, I like your question, because it is good that people understand that the orders we're talking about here, you can allow the process to finish in the lower court and then come for them, or sometimes you can even come for them in interlocutory, all right, in between, all right. But I think practically it is important that you wait, all right, and then you can, because imagine now if the matter is not finished, so you just rush, perhaps you might miss it gone. So wait and see the error, and then you move to the higher court, all right, to have these things overturned again. All right, let's move past that to prohibition, and then we end with mandamus. All right. Now, prohibition is a remedy which is used by the high court to prevent inferior courts, tribunal, or administrative authority from exceeding their jurisdiction, or to prevent them from violating the principles of natural justice. So this one is very technical: prohibition, certiorari, mandamus. So pay attention very much, because there's a thin line between the three of them. I repeat again about prohibition. It's a remedy which is used by the High Court or Supreme Court to prevent inferior courts, tribunals, or administrative authority from exceeding their jurisdiction, or to prevent them from violating the principle of natural justice. So basically, it is an order that is trying to prevent them from exceeding their jurisdiction. So it's in sync to some extent with certiorari. You can see that one of the grounds of certiorari is when some lower court is trying to exceed its jurisdiction. So prohibition is very key. But let's look at what separates prohibition from certiorari. Alright? So it simply can be used to prohibit an inferior court from exceeding or continue to exceed its jurisdiction by presiding over a case which is outside its jurisdiction to hear. Now, what's the difference between prohibition and certiorari? The difference, however, lies in the fact that while prohibition is concerned with the future, certiorari is concerned with the past. Alright? So prohibition is concerned with the future. You are trying to prevent the lower court from continuing or even not attempting anymore to sit on such matters, because it doesn't have jurisdiction to hear those cases. Whilst certiorari is about the past. Perhaps it has sat to the matter already, and which of course they have no jurisdiction. So they're now coming to the high court to quash everything. Alright, but for prohibition, you are trying to prohibit. Alright, let me put it that way. Prohibit the court from continuing, to sit on something it has no right to sit on. Alright? But the two remedies can also be applied for together or separately. So you can apply for certiorari order together with a prohibition order. So for example, the lower court had sat on a matter for which it lacked jurisdiction. You coming to the high court to quash that, and then you're asking the high court again through prohibition to prevent that court to continue or attempt anymore to continue to sit on the matter. So it's a very, technical thing to do. As a good lawyer, you must learn to be smart to come perhaps for two or more of these orders. All right. So, for example, a decision by an inferior court can be set aside by certiorari, and a further unlawful action, such as an attempt to implement the quashed decision, forbidden by prohibition. So you are quashing it by certiorari and using prohibition to prevent a further attempt to even implement the decision. All right. So you forbid the court to not attempt to even look at it. All right. So again, like certiorari, prohibition is also a discretionary remedy, and disobedience of that order is punishable as contempt of law. And of course, the grounds again for which you can come to the High Court or Supreme Court for an order of prohibition are one, to restrain an inferior court from acting beyond its powers, or two, to restrain a violation of the principle of natural justice by an inferior court or advocating authority. So they share a similar, set of grounds with certiorari. Like I said, the difference between these two is that certiorari deals with the past and prohibition deals with the future. So you are trying to stop the lower court not to ever attempt, all right, to do that again, or to continue or to even implement the quash decision that has been sought by an order of certiorari. Okay. Let's move quickly to mandamus.
Yes, sir.
Yes.
Before we move to mandamus, which is the last topic, and in your presentation about habeas corpus, you made it very clear that habeas corpus means to produce the body,
yes,
to court. Can the president suspend the habeas corpus law?
What do you mean by president suspend the habeas corpus law?
Like preventing it from happening, preventing the authorities in charge to produce that particular individual to court.
Oh, okay. So now I get your question. So, but let's make it clear. So, for example, if somebody is detained,
yeah,
all right, by the police, let's say, for example, by the police,
yes,
and that person has been in detention beyond the constitutional period.
yeah.
So we have for misdemeanors, we have 72 hours, 3 days, and of course for felonies, murders, economic crimes, we have up to 10 days. So assuming those periods have elapsed and somebody is still in detention, so anyone, of course, a lawyer can also be useful, can come to the High Court when the police is refusing to release the person or charge the person to court and secure an order of a writ of habeas corpus, okay, compelling, of course, them to produce the body. So that's the general, situation. But then, in situations perhaps like we are in now, in a state of emergency, where the Constitution puts enormous powers on the president, there are sections in the Constitution that can be invoked to still keep someone in detention. That's why we should not be happy about state of emergencies and don't take those decisions lightly, because they can be used to limit fundamental rights. All right. So generally, in a normal situation, we expect the police to obey the constitutional limits, and where they don't, it could be a grounds for us coming to the High Court or the Supreme Court to ask for a writ of habeas corpus to forcibly to produce the body. All right. And then it's up to the person to definitely bring a cause of action against the police or anyone that has illegally detained them. All right. So yes, I agree with you. The president and constitution has powers to keep someone to allow someone to be kept beyond the constitutional period, especially in periods of emergency, when those powers can be invoked. All right.
Perhaps not for the law students, just for the curious minds. In principles, the three reliefs, also known as the extraordinary remedies are
Yes.
meant to strengthen the inherent powers of the higher courts.
Yeah, but specifically the Supreme Court and the High Court.
The High Court.
Yes. Remember, we have in the ladder
To enforce their orders.
Yes, we have the Supreme Court at the apex. We have the Court of Appeal, the High Court, the Magistrate Court, and the Local Court. So we are talking about just two courts in the hierarchy. These are the courts that enjoy these powers. Yes, like you already said, to enforce their supervisory jurisdiction. So they supervise these lower courts, and then sometimes they tell something to do, they might not want to do it. So they have powers now to force them to do it. So they are basically powers in their hands to compel compliance to their directives.
Yes,
Right?
sir. Yes, sir. The court of first instance, which is the magistrate court, has got jurisdiction over the local court
Yes.
as supervisory jurisdiction. In that instance, do they exercise these remedies as well over the local court? I mean, the magistrate.
It's a very important question, because when we look at our topic on jurisdiction of the various courts, we noticed also that the magistrate court has supervisory jurisdiction over local courts. The Court of Appeal has supervisory jurisdiction over the High Court. So the question is whether what was the drafters of the constitutions? You know, were they partial? Were they impact? Were they not? Were they biased to just choose these two courts and ignore the others? Well, they all have supervisory jurisdiction, but perhaps they lacked the powers given to these two. And of course, for good reasons, because you know the High Court sits strategically, perhaps in the middle, and of course the Supreme Court is at the apex. So you must arm them with some powers to enforce compliance. But again, the magistrate court can enjoy supervising local courts, although they may not compel them by these powers, but I'm sure they can also help them out in many ways. All right. Let's finish quickly and then we can have some interpretation. So now, mandamus. Alright, so there's a group of students here who can also ask questions even as you ask yours online. So mandamus simply means we command. We command. We command. It is a judicial remedy in the form of an order from a superior court to any government, subordinate court, corporation, public authority, or lower court to do or forbear from doing some specific act which that body is obliged under law to do or refrain from doing. So this is a very strong power. So it's saying we command, mandamus. So it's compelling the lower court or an administrative authority to forbear them from doing or from even restraining them or asking them or forcing them to do a particular thing that they have a duty to do under the law. So it could be from restraining them from doing or forcing them to do. Mandamus, we command. So when you see the High Court or the Supreme Court, issues this order, it means something is serious. It means perhaps a lower court is disobeying. A lower court is not acting, in compliance to a public duty under the law. So it's a very strong order. Simply put, it's an order to enforce and compel the performance of a public legal duty. Okay, statutory or otherwise. For example, an order of mandamus may be granted in situations where a minister is exercising his discretion in such a way as to frustrate the underlying policy of a statute. So if you see a minister, so these orders also cannot necessarily be just for courts, all right? It could be for adjudicating authorities or other bodies, tribunals, okay, that are being held out of perhaps even a courtroom, all right? MDAs can set up tribunals, panels, investigating bodies, all right? So you can also seek these orders for them, all right? They can compel them. Okay, they can ask them to produce the records. They can require them to quash the decision. So it is not, let me make this point very clear, it's not basically a lower court all the time. If any adjudicating authority exists, or any tribunal, any investigative panel has done some work and it has not followed due process, you can come to the High Court or Supreme Court to secure these remedies. All right, these
including
orders.
commissions of inquiry?
Yes, all of them. They are educating authority bodies. All right. So you can always seek these orders from these two courts. So both mandamus and certiorari can also be applied for in the same proceedings. So I just told you that you can apply for certiorari and prohibition in the same proceedings. You can also apply for mandamus and certiorari in the same proceedings. For example, the decision of an inferior court or adjudicating authority, which is ultra-vires, may be quashed by certiorari. So the court or the body has sat on a matter it has nothing, no business to have sat on. Alright? So that can be quashed by another certiorari. Now, and the authority compelled by way of mandamus to hold a proper hearing in the matter. So you can quash that by certiorari, and then you at the same time ask for a mandamus to now compel them to do the right thing. In other words, to hold a proper hearing on the matter. So you can come to the court for both certiorari and mandamus, as you can come to the court for both certiorari and the prohibition. Alright? So certiorari, quash everything, overturn it, set it aside, because it was not legally properly done. Prohibition, stop them from not even thinking of doing it anymore in the future. Now mandamus, compel them to do the proper thing. Alright, so you can come for these remedies, jointly, alright, or singularly, as the case may be. Okay? So it's important to emphasize that mandamus, like certiorari and prohibition, they are all discretionary remedies. And the High Court may refuse, or Supreme Court may refuse to grant them if the applicant has delayed in seeking the relief, or where there are other suitable remedies for enforcing the legal duty. Alright, so the court is not bound to give them. So they are not as of right like the writ of habeas corpus. They are discretionary. The court will look at other, alternatives, and if they are suitable, then it will not allow these ones to stand. So it's not as of right. It's discretionary. It's at the court's discretion to grant or not grant them. That is very important for us to also remember. But disobedience of these orders is contemptuous, and definitely it will not be good for the lower court or any body out there that disobeys these orders given by the High Court and the Supreme Court. So they are contemptuous if you disobey them. Now here are some examples where the remedy of mandamus had been issued. Let me give you two cases. One, we have Metropolitan Police Commissioner ex parte, okay, RV Metropolitan Police Commissioner ex parte Blackburn, 1968, where a mandamus order was available to compel a chief constable to enforce the law against gaming and pornography at the request of a citizen, even though he could have started a private prosecution. Alright, so the chief constable was compelled by mandamus to enforce a law against gaming and pornography. Then also in the case of Padville and Minister of Agriculture, a minister was compelled to perform a public duty required of him by a statute. So where a mandamus was obtained to enforce the minister to perform his public duty, which directly affected the plaintiff. So there was a mandamus order that was obtained to compel the minister to perform its duty because the omission was affecting the plaintiff. Alright, so these are instances where you, of course, shows clearly that the court can order a relief of mandamus because a public officer and the authority here are refusing to do the right thing under the statute. So it compels them to do the right thing. We saw one on the chief constable, alright, basically like the IG, and then we have one on also a minister. So it is important for us to know that you can come for this remedies, not necessarily for just a court structural situation, but also for people who are under a public duty as required by law. Alright? Now let me conclude by saying that it's vital to point clearly that all of these remedies we have discussed today fall under public law remedies as distinct from other private law remedies. So we have other private law remedies and we have public law remedies. So these are public law remedies. Now for private law remedies, we have damages, injunction, declaration, and the like. So if you want to also come for private law remedies, you can ask the court for an injunction, for damages, for proper performance, for example, for declarative orders and the like. So all of these must also be put to context. We have the public law remedies and we have the private law remedies. Alright? So today I'm sure I have been able to help you in a little way to understand prerogative remedies and orders, and we have looked at the order of writ of certiorari, writ of habeas corpus, mandamus, and then prohibition. Mandamus, we command. Prohibition, of course, prohibiting the court from continuing to do the legality. Certiorari, it means we wish to be informed, and of course, writ of habeas corpus simply means produce the body. All right. So these are all remedies and orders available to the High Court and the Supreme Court for them to be armed with powers to force lower courts below them to comply with their directives. Basically, that's what it means. All right.
Rashid,
So perhaps we may have some questions.
Yeah, Rashid, a very quick one. I'm seeing the technicians signaling for the end of the program. What's the risk therein a question that is from the High Court or Supreme Court or the demands of the applicant for either a mandamus or a prohibition, for whichever way you look at it, that the risk of undermining the spirit of trust, especially of the magistrate courts at all times?
Yeah, well, that's the beauty about the law. It hangs on appellate processes. So these are also, in a way, ways to challenge. That's why as lawyers we don't fight when a lower court makes a decision that you think is unsatisfactory. What you do is you go up by your appeal, or you go for these orders, all right, and then remedies, and then see what will happen. So it's all part of the due process, and it makes the law beautiful because at the end of the day, you are trying to let the lower court know that what it did was not, in line with the law or due process, and a superior court has agreed to your position. All right.
Yes, sir.
Yes, quickly.
Looking at mandamus, habeas corpus, and that of certiorari, which of these three guarantee the personal freedom of individual?
You mean, okay? So you're talking about. Okay, let's put it this way. Maybe a writ of habeas corpus. Remember, you are trying to secure the release, okay, of someone who has been illegally detained. So that's a personal, perhaps, benefit, because the freedom of the person will definitely be secured. But in all of this also, you don't know who you're bringing it for. Remember, perhaps somebody also, the right of somebody has been abused, perhaps, or violated. The person has gotten an unjust ruling, so it also has personal benefit in an indirect way when these decisions are quashed. But for a direct, personal gain, it has to do also with the writ of habeas corpus because you are securing the release of someone who has been illegally detained.
Yeah.
Okay, lastly.
Yes. So, what is battery in law, and what's the thin line between battery and assault?
Yes, well, it's a very technical thing because many times people have a way of arguing it. But of course, battery constitutes assault. So assault is the baseline. When of course just the mere touching of somebody without the person's consent could also be described as assault. Perhaps battery can go to something aggravated. All right, when you not only touch, perhaps you do something much more physical that perhaps created injury or damage and the like. All right. So it's all about context, but of course battery will include assault. No. All right. So I think our viewers online are deprived today of their text and message.
Well, I think
right.
for a start,
all right.
Yes, we'll have a collection of all of those concerns or questions being forwarded to the technicians and give them to you in the next edition. Before we commence in the second lecture,
okay,
you have the opportunity to actually respond to them.
Yes.
Then we continue with it.
Okay. So thanks viewers and thanks Star TV. It's the maiden edition. We hope to improve on it next session. But I'm sure if you are at home and you are on live, on Facebook, Star TV page. I also learned that also on Zoom and the like, you will have enjoyed our first class. All right, let's manage it. It's tough, but I'm sure gradually we will understand the concept. And if you have your questions, just send them in. On the next class, I'll take them first before we go to the next topic. So see you again on Tuesday. Yeah, Saturday we'll repeat this broadcast, and Tuesday we'll have a second topic. I'll let you know the second topic that will commence on Tuesday by weekend. Thank you very much for watching. This is a program sponsored by Star TV, and in case you're out there, you want to help sponsor this kind of program and invest in it, of course, it's the best place to be. And of course, we will appreciate. Come to Star TV, meet the manager, meet the director, Mr. Philip Neville and Mr. Roman, and then talk with them and see how we could make it much more a unique program, well broadcasted to many stations, hooking up so that we can have a larger audience. And of course, you're a lecturer out there also. why not? You can come in and let's do this together. Thank you very much. I'm grateful.
Law for non-law.
I must say it's so very much wonderful kind of presentation. Hope the audience had a very wonderful time. You have to tune in next week for another edition of this program.
Yes, law for non-lawyers. Thank you.